also want to invite my colleague Iris Lee from the Office of Small Business Development to introduce themselves as well.
Good morning. Thank you for having me, Hawat. Hi, y'all. My name is Iris Lee. I'm the commercial leasing specialist here at the Office of Small Business. I'm here to support everyone, small business owners, through their commercial lease negotiations, finding spaces, as well as doing some lease review when you are able to get to a lease. And I'm really excited to be here. Thank you for having me.
Thanks for being here. Again, it looks like we just started the recording, so just want to repeat again, my name is Hewitt Shankut. I'm with the Lawyers Committee for Civil Rights in San Francisco Bay Area. So we're going to be diving into our presentation today on commercial lease negotiations and commercial tenant rights. And on the next slide, provide a little bit of a roadmap on the issues that we will be addressing. And so we'll kick off our conversation on a baseline introduction to commercial leasing and some of the legal mechanics that goes into preparing for that contract of agreement for real estate with a focus on commercial tenants and what commercial tenants need to know. And then we'll discuss the process of reviewing material terms and leases with a particular emphasis on rent and duration, as well as repairs. And then we'll also have conversations around negotiation strategies, some tips, things to keep in mind as you navigate your commercial leasing needs and get what you need in your leases. In addition, we'll talk about the new commercial tenant rights that have been provided under Senate Bill 1103. And we'll have I'll provide some input throughout just to flag later discussions that provide a bit more of a comprehensive overview. And then we'll end with questions. But I do want to invite folks to share in the chat, if you're comfortable, what you're hoping to get out of today's training, just so that we can keep the themes that you're most interested in at front of mind. And so definitely welcome you to do that. Drop any questions in the chat as they come up as well. We'll be pausing at each section to address those questions somewhat simultaneously as we're going along. Definitely also want to make sure we get through all the content, but wanting to invite folks to share what's top of mind. And no matter what, we'll definitely get to all the questions by the end of the training. And so with that, we'll go to the next slide. I'll be reading a disclaimer about what you need to know for today's presentation. So all information, content, and materials contained in this presentation is for informational purposes only. This presentation is intended to be a general overview of the subjects discussed and does not create a lawyer-client relationship. Statements and opinions are those of the individual speakers, authors, and participants, and do not necessarily reflect the policies or opinions of the Lawyers Committee for Civil Rights of the San Francisco Bay Area. The information contained in this presentation is not and should not be used as a substitute for legal advice. No recipient should act or refrain from acting with respect to any particular legal matter on the basis of this presentation and should seek legal advice from counsel in the relevant jurisdiction. Prior results do not guarantee a similar outcome. And the Lawyers Committee for Civil Rights of the San Francisco Bay Area accepts no responsibility for any actions taken or not taken as a result of this presentation. I also want to emphasize that if you're sharing or asking questions in the chat, please be mindful of your confidentiality needs, as this presentation creates no confidentiality protections for the information that you might be sharing or disclosing. Okay, so with that, want to provide some information about who we are. So the Lawyers Committee for Civil Rights was founded in 1968 to dismantle systems of oppression, racism, and build an equitable and just society. It's one of the oldest civil rights legal organizations on the West Coast. And our lawyers and advocates work to advance, protect, and promote the legal rights of communities of color and low-income persons, immigrants, and refugees. We do this work through our vast network of pro bono attorneys from the private bar. And we also provide, through our partnerships, free legal assistance, representation to individuals on civil legal matters through three main service delivery models, which is our direct representation services, our impact litigation, and our policy advocacy. And we have three main practice areas at LCCRSF. It's racial justice, immigrant justice, and economic justice. And we are here representing the economic justice program, which on the next slide, we can share a bit more what it's all about. So the EJ program is committed to closing the racial wealth gap and empowering communities of color through our Legal Services for Entrepreneurs program, as well as our policy advocacy. So today's workshop is facilitated through our LSC program. An example of the ways in which we're providing free legal services to our low-income entrepreneurs and small business communities who are all committed to creating and building sustainable wealth in economically distressed communities. And this work is all for the goal of increasing business and economic opportunities to help enable individuals to have self-determination and control over their livelihoods and their communities so that we can advance a more equitable, more inclusive local and regional economy. All right, so what we will start off with now is just doing a general overview um, regarding intros to commercial leasing. And I already see a question about SB 1103. And so definitely note that as it speaks to applicability, and there's some technicalities around that that I want to give more attention to. So definitely we'll note that question for just a little bit. So want to start off with the next slide, which is just sort of laying out some of the key features of commercial leasing as a baseline matter to keep in mind. So first is that statutory protections under California law are limited for commercial tenants, unlike residential tenants in the state of California whom have a significant amount of protections that are offered to them, sort of that are implied in law. Those same implied laws don't necessarily carry over for commercial tenants in the same way, which is why the commercial lease agreement is really the ground, the legal source of law that governs the relationship between the commercial landlord and the commercial tenant. However, there's some good news that now with SB 1103, there have been some expansions for commercial tenant rights, and we hope that we can continue to expand those rights, and we'll talk about that as well as we go along in the presentation. And so the commercial lease is what governs the written contract that's represented by the lease is what governs the nature of the rights and responsibilities between the parties. And so this is the contract that the parties can enforce in court to get to get each side to do what they promise to do. And so courts will look to that written agreement of the lease to enforce rights and resolve disputes, which is why we'll be spending a lot of time talking about sort of the various considerations and things to keep in mind when reviewing as well as negotiating and signing leases. The next thing to bear in mind is the mutual benefit and the mutual exchange that's represented by the agreement. And where we really emphasize as commercial tenant side advocates is, of course, the value that tenants are providing to landlords, the benefit and the value that the commercial tenant is providing to the landlord in order to sort of negotiate from that position of value and identifying sort of the needs that are most a priority so that it can be addressed in the contract. And so that's a really important starting point. And then the next thing to keep in mind, which we'll talk more in detail about, are reviewing and identifying the material terms of the lease, the terms that have sort of the greatest legal and economic weight and significance. And so a very obvious one is the rent payment obligations. Really, that's a big one to kind of hone in on. And we'll talk about some of the hidden features that can go unnoticed about the total a scope of obligations. And so make sure to um, identify that and go through some of those factors together. In this presentation, we'll also talk about performance obligations as it relates to repairs and maintenance that's required for the leased premises. And we'll talk about how to allocate that and what to look for based off of what your commercial tenant build out or repair needs are. And then we'll also talk about the initial term and your occupancy rights, and as well as contingency planning for unforeseeable events that might, necessitate an exit or a cancellation of the lease, or even staying on in the lease. So by way of options to renew. All right, so with the next slide, I want to just do sort of a basic 101 of the legal components of a lease. And so a lease is a contract between a landlord and a tenant, also known as, might be known as the lessor or the lessee for the rental of certain space located on the property. And so a lease grants the tenant the right to exclusive possession and use of the property for a fixed time period, which in the lease is described as the term, in exchange for a specified payment of rent. And sort of this is the exchange of value that is sort of translated into the legal arrangement between both of the parties, and something to bear in mind as well when you're thinking about sort of your access and the total sort of property rights that are being conferred to you as a commercial tenant, and also the exclusivity of that. 'Cause sometimes there might be some spaces that aren't entirely exclusive, and so really the base rent is tied to the exclusively used part of the premises, and so we'll talk a bit more about why that's important. But as a baseline, that's where we're starting. And also the other thing to keep in mind is that lease agreements that are more than a year term, they must be in writing in order to be legally enforceable. Okay, so the next slide, just going to do a quick run through of some of the things to keep in mind before we get into specifics of commercial leasing. And so again, just to emphasize, in order for it to be enforceable, if it's a leasing arrangement for more than 1 year, it's got to be in writing, and that verbal agreements don't count. It's really important as well to have lease agreements or arrangements, or even, um, certain, conversations or promises that were had around the time of negotiations, for that all to be put in writing in order to avoid disputes or misunderstandings, or having like an incomplete agreement that, was supposed to include something else that was mentioned to you on a call by a landlord, but then eventually didn't get into the lease. You want to make sure that all of that is incorporated into the final agreement. And this, again, just to repeat, unlike in residential context, a commercial lease governs almost all of the tenant's rights. So just ensuring that everything is documented, documented, documented. And then before you sign it, so after it's been documented, so before you sign it, just understanding that the signatory and the identified tenant is the one who's going to be legally bound and obligated to perform the requirements and sort of the promises under the lease. And so it's really important to understand the fine print. And also to that point, we'll talk about how SB 1103 has also enhance lease transparency, in that if a lease was negotiated in a language other than English, that lease has to be translated by the landlord before it will be valid. And so again, just wanting to ensure that that we have a landscape where parties are able to enter into agreements that are understood and that are in languages that is accessible. And then also ensuring that you have a lawyer review and explain the lease to you before signing it, if at all possible. And so definitely want to shout out our program as a resource for you if you're interested in getting an attorney to provide you a consultation. and to ensure that there's always opportunity to ask questions and to never feel any pressure to sign something you're uncomfortable with, and even asking for more time to review, as sometimes landlords are pretty masterful at creating sort of artificial time pressure. So just ensuring that you have all the time you need to be able to review as much as possible. And lastly, before we head over to the next section of the slide, and I'll pause for questions before that, want to also emphasize the importance of negotiations. That's why we're here, is to talk about how to do that, but just to emphasize that, you know, even if you get like a standard form of commercial lease from a landlord, and you know it looks super official and as if the terms are all static and can't be changed, you know, the truth is that all terms and clauses are negotiable. You can ask for what you need and be able to navigate it from a place of really trying to get what you absolutely what is workable for you. And before signing, that's when it's, you know, the most advantageous time to ask for what you need. It's always easier and better to do that at the beginning as opposed to after signing the lease, because then you'll already be bound to what you know what you've promised to do. And so ways in which to think about negotiations, and we'll sort of talk, you know, practice this a little bit more as we go along, is just really getting critical about the specifics of each clause, especially clauses that have to do with um, you making payments or you making repairs or being obligated to do something or not to do something. You know, those provisions, just being able to hone in on who is responsible for what and for when and how much, and to really sort of get a better understanding of sort of how the implications of those provisions by you know, exploring these important questions, as well as thinking about the worst case scenario for each clause. This is sort of the lawyer's training, is to, you know, try to think about what could possibly go wrong, or what are the particular risks that might be associated with you know, a particular provision. And sort of in the same way as a small business, well versed doing these sort of analysis for your own business as well, sort of thinking about ways in which to protect your interests, protect your employees, to protect your goals of wanting to have long-term stability for your lease, and sort of thinking about the different provisions that might have some bearing on those considerations. And you know, the main thing is to just be fully prepared, right? You want to know what you're going to be, what you're signing up for. And so even if the answer is no, at least you know what you're dealing with, and you can use that information to decide what your next best step is. But you know, the key is you really know what's coming, and to be able to address those issues in the lease if at all possible. And if not, that's also valuable information. So I did want to pause there. Um, to see if up until now there have been any questions, and I'll just let you kind of let me know. Otherwise, I'll proceed along. And like I said, it did note that SB 1103 question, and we'll get to that shortly.
Yeah,
All
looks
right,
like there's no additional ones in the chat other than the SB 1103 question. Um,
gotcha.
you can go ahead.
Okay, thank you. So let's carry on our conversation. And again, feel free to drop into the chat or in the questions, anything that's coming up for you. All right, so let's talk about the nitty-gritty. So for commercial leasing, really three key things to keep in mind as we're navigating how to review and negotiate. It just starts with the preparation, reviewing, and negotiating. Ultimately, you know, what you're wanting to get in the deal. And so we use this slide a lot of times to just offer a grounding as to the position that we start from when engaging in negotiations, which is really assessing the exchange value and benefits of the transaction from the standpoint of a commercial tenant, a small business, an entrepreneur, right? Sort of the value that you're bringing as a small business to the commercial landlord is really important because it's from that foundation that you'll be able to identify what your specific business needs and priorities are. And sort of doing that homework on the front end, sort of irrespective of what the landlord is demanding, sort of providing yourself that roadmap that you want to use to help inform your negotiations can be a really powerful starting point. And so we know that the landlord is going to benefit from the commercial tenant in many ways. So the first one is by getting rent. And so having that, continual, consistent monthly cash flow in commercial real estate, industry relies on that. And so that's a really important thing to bear in mind. It's obvious, of course, but at the same time, to be able to internalize that value, I think goes a long way. And so someone else is taking care of the property that the landlord owns. So essentially you would be, if there are allocated repair and improvement responsibilities, that you would be the one who's doing that. So essentially, you're providing that very valuable resource to the commercial landlord. And again, something that you should know. And then the next thing too is that depending on the type of lease that you have, it could be that someone else would be paying the landlord's part of the property taxes and other expenses as well. And so again, that's incredible value that's being put on the table. And then lastly, what the tenant gets to benefit from, when you're thinking about this exercise is that when you have that fixed space and location, you're able to have this ability to operate the business in a way that will help, meet your own legal, meet your own business goals. All right, so I think I see a question here. You have to leave a space, commercial space, due to a lack of an elevator in California. Is that a legal way to get out of a sublease? I knew there was not an elevator, but didn't realize how much it would affect my business, and I left 6 months early. Got you. Okay, so this seems like a very specific situation, and it looks like there was a sublease. And so when when looking at sort of what is allowed and not allowed, you've got to look at the sublease in order to get a better understanding of what is like a permitted cancellation or termination of a lease. And so when you mention elevator, it kind of has me asking a little bit more questions, maybe even compliance with American with Disabilities Act. And so I definitely think that it might be better for us to gather more context about that question and invite you to attend our clinic that may be coming up for a consultation with an attorney, because it seems like this is a more specific question. But we will be getting to subleases towards in the next few slides, and so definitely we'll sort of keep this in mind and try to speak more as to what to consider when subleasing. So yeah, just definitely hang tight. We'll be getting to that, and then we'll have more information about a legal clinic for consultation on your specific question. So for the next slide here, and excuse the formatting issue, looks like it did an update. We'll be talking about rent. So this is a big one. This is a key material term that is on everyone's mind when you're negotiating a commercial lease, right? And so we want to spend some time here in terms of negotiation strategies to think through different factors to consider when addressing rent. And so the next slide talks about understanding rent obligations. And so rent, in terms of the legal implications of rent, is that it's the price the tenants must pay to the landlord for the legal right to possess and use the commercial rental property. And so there are really there are a couple of components to rent to keep in mind when you're reviewing your commercial lease, right? And so the first is the base monthly rent. And so this is the minimum or the stated monthly rent that the tenant pays regardless of revenue. So regardless of how much money your business is generating, that this is what, the commercial tenant is agreeing to pay a specific dollar amount per month to the landlord for the right to exclusive use and possession of the lease premises. And so usually this rent is calculated and based on a dollar per square foot amount, or if it's not, it should be. And so we'll have some conversation and invite Iris to speak more to that in the coming slides as well, in terms of how do you determine what fair market rent is and sort of what different resources you can look to evaluate that, or different factors to consider. But definitely base rent is really the key term in the lease that you want to dial in on, because that's also going to be the basis upon which any rent escalations or increases will be applied to. And so that's one of the key numbers to zone in on. And then you have, as part of rent, like I mentioned, any fixed increases to base rent. And so these are the annual increases that are set in advance that will go into effect at the start of each new term. Um, and so, that's one part of rent, but that's not the only thing that constitutes rent. You may have additional rent. And so this isn't always apparent in the lease, but your lease may include something called percentage rent, which is in addition to the base rent, you may be obligated to pay a certain portion in the amount of a percentage that's based on the sales that you've generated from the business. And so that might be added on. You may also be required to pay operating charges. And so this comes into this is defined as expenses that are associated with operating and maintaining the property that benefit the landlord as and other tenants if it's a multi unit property. And so this could encompass common area maintenance charges, also known as CAM. And so I'll be using the acronym CAM, and so that's Common Area Maintenance. It could also include charges for property taxes and property insurance as well. So if it's all three of these expense categories, then that's what's going to be described as a triple net lease, or triple net expenses. All right, so um, and the one other thing I'll mention too, and sort of we'll talk about this some more, is that the base rent typically, so this is the minimum monthly rent, is usually based on square footage. And so you want to make sure you're taking your own measurements, if at all possible, of the unit to make sure that you and landlord are agreeing on the size of the space, and to be able to state that in the lease. Sometimes the landlord will include in the lease a disclaimer that they're not confirming the size of the unit, but if at all possible, try to push back on that so that there can be shared agreement as to the square footage, because the base rent will also, if you're using a dollar per square foot um, uh, factor for rent, you can obviously see how important it is that everyone's on the same page about the size of that. And also, if the size either shrinks or expands for whatever reason, of course, it would have to be a legitimate reason under the lease. But let's say if that does happen, you want to ensure that, especially any reduction, that would also translate to a reduction in the base rent calculation. So, other questions to consider are, when do you have to start paying that base rent? Sometimes there could be a different lease commencement and a rent commencement date. And so that would delay when rent is due. If the landlord is supposed to be doing certain improvements or making certain repairs after providing you the keys, which effectively is them delivering possession of the premises to you. But let's say if the unit is not really is not yet ready for your business to open up because the landlord still has some work to do. Again, that's where you can negotiate to have an extension on when rent becomes due. And also, just considering those different factors, which we'll be able to talk about more around more of the pass-through costs too. So on this slide, we'll talk about exactly that. And so in addition to understanding rent obligations, it's important to understand what kind of lease do you have, because there are different kinds of leases, and leases don't always have the exact title or, some kind of clear defining marker of the type of lease that this is. And so sometimes you'll just be cobbling together different provisions or different things that were said about extra charges and not be clear about how to categorize your lease. But here are the things to keep in mind as to the types of leases that are out there, and you can even evaluate to see if this is something that kind of resonates with the lease that you may already have right now or are considering. And so the first one is the gross lease. And so in the gross lease, the landlord is charging the tenant base rent and the landlord's covering all the property expenses. And so they're assuming and all the property management and ownership costs. They're not passing that on to the tenant. And so in this case, the tenant's only paying the base rent and possibly utility charges if it's a modified gross lease. But sort of that's like kind of the basic lease, I'll say. I won't say it's like standard, but it's just sort of basic lease where tenant's just paying base rent. Now you have net leases. This is where things get a little tricky, is where the landlord charges base rent, but then will also pass through a variety of additional costs that are associated with property ownership and maintenance expenses to the tenant. And so here you'll have a single net. You might have a single net lease where landlord's only passing on a portion of the real estate property tax costs to the tenant as rent duties. Double net is when the landlord passes on property taxes as well as the building commercial insurance expenses to the tenant. And then this one, the last one is more popular. It's the triple net lease. So that's where the landlord's passing on the property taxes, building insurance, as well as the common area operating expenses or the CAM fees to the tenant. Sometimes there may be a calculation of load factor where the common area usage is split up amongst all of the tenants, and that is added on to the value of the base rent. That is separate from the CAM charges. And so I recently negotiated a commercial lease that had both CAM charges as well as load factor, but a very low base rent in order to balance that out. And so again, that goes into leveraging different terms of the lease in order to find sort of that sweet spot that works for you as a commercial tenant. But yeah, so that's definitely important to be just clear about what the full scope and also the type of lease that you have. It's not to say that one lease is better than another because you sort of have to weigh all the different elements together to see if it pans out for you. It could be that a triple net lease is actually much more economically sustainable than a gross lease that has a very high base rent. So it all depends, but the main thing is to just be really clear about what the total obligations are. And so I have an example here about ways in which some of the fine print can get hidden and kind of run into issues later on when there's been misunderstanding about the total scope of lease obligation or rent obligations and the type of lease. So um, here we had a tenant come to us because they thought they were paying 3,800 and that was really the base. That was like the scope of the conversation for rent in San Francisco for this particular area. And later on, they were starting to get a bill, and it had an additional charge to the 3,800, and it amounted to about 40%, like an additional 40% rent obligations to the 3,800. And so, they were just surprised when the landlord sent them this ledger of accrued triple net expenses and then pointed to this very obscure reference to triple net and this triple N in the lease where there was nowhere else in the lease that talked about triple net costs. And so, that turned into a situation that we needed to handle with the landlord. Fortunately, we were able to renegotiate the lease terms and have that particular provision addressed and also renegotiated. That doesn't always happen, right? Especially if it's already been sort of laid out in the lease like this. I think that what we were fortunate enough to have is that there was nowhere else in the lease that actually spoke to this. And there was also other evidence to demonstrate that the lease negotiations didn't include discussion of the triple net. And so fortunately, with getting an attorney to look into this and maybe um, approach the landlord's attorney if they're represented, or even with a letter, indicating the invalidity of, this particular type of situation, you could be able to, find a pathway to renegotiate, but not always, right? So just wanting to make sure in the front end that we catch these things by seeking out legal assistance, or even being able to flag it now that you know. Okay, so again, just emphasizing to define any undefined terms that might come up on that prior example. Awesome. So great. Thank you so much for proceeding with the slides. So we have here just kind of a breakdown of, we're going to be heading into negotiations. And so really excited for you to hear from Iris Lee a little bit here. But just trying to do like a snapshot of a projection of 3 years for the total annual rent and utility costs under a triple net lease, because this is a good visual just to help navigate and think through your own commercial leasing needs and considerations as well that come up. I know when we go through this exercise with our clients, it's always a clarifying moment to really zone in on things that need to be addressed or clarified or even taken out of the lease. So, in this hypothetical, we have a base rent. So just going back to what we discussed in the last slide. So the base rent is not inclusive of any potential CAM fees, building insurance, utility. It's not that. It's just for the right to possess the unit, sort of the basic rent that's required. It's not all of the rent, but it's just the starting point. So it's $4,000. In addition, you have rent that's calculated for the operating charges for the building. So there's a portion of net costs that the landlord passes on. And then this particular hypothetical, there's also percentage rent. And so this is all monthly. So we have a monthly rent obligation totaling 6,500 in this particular example. And then there's a total annual rent obligation of 78,000, but it doesn't stop there, because we also have in the lease considerations around the rent escalations, right? And so that's factored in as a $1,000 base rent increase. Usually annual base rent increases are tied to the consumer price index, or it's capped at like either 2 or 3%. Usually 3% is what I've seen, but here we've just done 1,000 just to simplify the exercise. And then we have a utility expenses for about 500 a month, right? So that can fluctuate. But again, these are all total. This is like the total cost of the lease, if you will. So if you have a 3-year lease, you're looking at the first year being 84,000 annually in terms of rent obligations, total rent obligations. The next year, 102,000, and then the third year, 120,000. And sort of these are all valuable projections in order to be able to assess what is a financially sustainable lease, because ultimately, this would be what the commercial tenant would be legally liable for if they were ever to be in default for non-payment of rent. And so, important sort of clarifying exercise. All right, so the next slide is negotiations. So how do we get what we want in the lease on the rent terms? So the first step, really, like we said earlier, is to just always start with the value that you're bringing to the table in order to evaluate your needs. And so, that starts from just, again, recognizing valuable cash flow, as well as the property maintenance and enhancement factors that the tenant is providing to the landlord, as well as sharing into the costs of, property ownership in the form of property tax payments, etc. So with that, I do want to pause and just invite Iris to share any input and invaluable resources, as well as you're navigating negotiations around rent.
Thank you. Yes, there's a lot of value that you've established already, and I just reiterating that and establishing the value and kind of bringing that value to the table, and helping the property owner understand that value that you're bringing. Oftentimes, I like to advise folks who already have a business plan to kind of put together an executive summary which highlights your business, right? If you are negotiating with an agent or a broker who's the in-between person, then you're usually relying on them to represent yourself and your business. The executive summary is a document that you can prepare that has images, what your final product will look like, what your business will look like. as well as some financials and information about yourself. And that really helps with bringing the value. I also do want to mention that the LOI, which is a letter of intent, is a non-legally binding document that is usually used to negotiate the core terms of the lease. So this is before you get to the lease. And this item can really be helpful in negotiating those core terms that have been emphasized, the rent, the value that you'll be bringing. With that value can include tenant improvements, any construction or intended changes that you make to the space are items that can be evaluated, and we can help you understand those so that you can confidently negotiate. Understanding if you are doing any of the permits, the improvements, what permits are needed, what are those timelines. We also have permit specialists here at the Office of Small Business that can help you understand that timeline, that can also help inform that negotiation point as you're doing that. And I think I'll pause there. I think I can get a lot deeper into it, but I can wait till the next slide.
Yeah, it's such an important point as well in terms of the letter of intent or the executive summary before signing the lease, having the business terms all sorted out because that'll serve as the foundation for the commercial lease. So, with that as well, wanted to go on to the next slide to talk a little bit more about how to research rent. So this is a really big one um, to really do your homework on before coming to the table. And so definitely also want to hear a little bit more from you, Iris, around like some things that we should keep in mind as we're looking into that term of the lease.
Yes, happy to. So, with your business plan and your executive summary, ideally you have an idea of where your customer base is, right? What neighborhood you ideally like to locate your business in. Sometimes some folks don't have an idea yet, which is also okay, right? You're still discovering where you're looking. If you have an idea of where those neighborhoods are, you're welcome to reach out to us here. I'm the commercial leasing specialist. I have a commercial leasing advisor as well who can help you understand what those market rates are for those specific neighborhoods. Downtown, we're likely to see the higher price per square footage rate, including more triple net leases. Central City, we're probably seeing a little bit of mix of triple net and gross leases. And then, of course, in the western parts of the city, we're looking at more commonly gross leases. And lower price per square footage just due to general traffic, right? And general foot traffic and density of the neighborhoods. So doing that research is really important for you to understand and how you can budget that into your business plan. You're welcome to also use agents or brokers. You often will see their names listed on properties. It doesn't hurt to call them, interview some different agents and brokers, really go with your gut on, interviewing somebody to help you find the best space for your business as well. Um, those are kind of how we determine the price per square footage. And then there are many other factors that go into the comparables, right? The condition of the space, the square footage of your space. If it's a larger square footage, let's say bigger than 4,000 square feet, that price per square foot is likely a little bit lower, right, to accommodate for that. If it's a smaller square footage, let's say maybe 200 to 500 square feet, you're likely to see a higher price per square footage, just the nature of the real estate industry and how that kind of drives that. The condition of the space is also something to be in mind of as you are doing research. Is it a space where you're going to be investing and doing that improvement to make it, let's say, a cafe space? If so, and you're putting in that capital, likely you're able to negotiate a lower base rent to start with those annual increases built in to kind of catch up eventually, likely a few years down the line. If the property owner does not have, let's say, capital to contribute to the project or is not doing any of the work for the space, usually that's where we're able to negotiate that difference of time between the lease commencement and the rent commencement, right? So that's often termed as the rent abatement or the free rent period. Valuing and getting estimates from contractors or architects to understand what your true costs will be initially can help you understand how to negotiate how much free rent to ask for as well, or how to get creative with the deals, right? How to get free rent in the beginning or lower rent and kind of mix and match. There's a lot of different ways to get creative, and that's how we here at the Office of Small Business can help you understand that and think about those different scenarios as we are doing that research. Um, and yeah, of course, downtown, as I discussed, the downtown, the waterfront, all of those you're likely to see higher rents, even though they have been vacant for a long time. That is generally what is happening in the city with our vacancies downtown. We do not track vacancy rates. It's not something that's really useful for us as the market does change pretty often. So it's really understand, getting into those neighborhoods of reaching out to the merchants associations or the community benefit districts. Those are local organizations that are hyper focused in those communities that you may be seeking to locate your business into, who can have that data, who can understand what it looks like for this type of business that you are looking to locate into the space. And then of course asking. Yeah, I always advise folks, everything is negotiable on the table. Whatever the property owner says isn't always set in stone or has to be the end all be all. We must ask how can we get creative, where are we able to kind of lower some costs, and where can we recoup that in the back end if possible. um, Leveraging is always great. Leasing the terms and the options, looking to see, as I mentioned, how we can get creative with what is being inputted, or if there's a space that is turnkey and ready to go, what is that value? Is this a affordable housing component where you're able to bring in an affordable menu set for the residents upstairs, and then also have a market rate set for other folks who are walking by and coming to your business? Or is it a market rate building and you're bringing in a concept that the property owners are really looking for? Those are all different ways to get creative and kind of constantly communicate with the person who's either negotiating on your behalf or helping you negotiate with the property owner, or directly with the property owner. I think communication is key when we are looking at negotiations.
Awesome. Thank you so much. And there was a question, actually a couple questions. So there was one about responsibilities for back billed utility payments for a shared space that hadn't been asked for over a year, if that is valid, if that can be back billed. And so ultimately, whatever is in your lease that you've agreed to, and that can be performing payment obligations for utilities based off of some, arrangement that, you'd be obligated to perform that. I mean, subject to the statute of limitations. So if it's been over a year, it doesn't necessarily mean that you wouldn't be held responsible for it just because they didn't ask you for it. I mean, especially if it's already stated in the lease that there's an obligation to pay that. So, but definitely worth taking a look at. Maybe there's some other caveat in the lease. So definitely, again, invite you to speak with one of our attorneys at a legal clinic. And then another question that's actually spot on, to what you just provided an overview on, Iris, is whether there are any resources or sites to look to for comparable rent data for the area, if you have any recommendations on that.
Sure. I don't believe there are any public data. I mean, surely I think you can, if you Google things, things will show up.
Yeah.
It's really difficult, I think, to hone in on a specific site for comparable rent for an area. I think it's really reaching out to those folks who are working in those areas. As I mentioned, community benefit districts, let's say, for example, the East Cut or Yerba Buena, and then looking at merchants associations, either Inner Sunset or Glen Park, they'll have a better idea of what's been going on in the neighborhood. Always reach out to our office. We are seeing deals all across the city. So oftentimes we have that just firsthand information just based off of our experience and the work that we're doing. So we're able to give you an advice of range at minimum. Downtown, I could say I'm seeing maybe anywhere between $3 to $10 a square foot, and that's a wide range. And likely those are more, triple net leases. Let's say Central City, Fillmore, we're looking at high rents as well, probably closer to that $5 per square foot range and up. Marina District, similarly, the TL, likely we're seeing lower rents as an example, right? Due to some street conditions, which have been improving, from what I've seen and what I've heard. But those are opportunities there if you're looking for that lower basement and looking to build in and kind of mesh in with the existing community that's there and continue to grow. Otherwise, Central City and Western, I would probably say anywhere between a $1 to $3 square foot or more range. As I mentioned, it is a big range and it really is hyper focused and determined on the condition of the spaces and the details of the lease. And hopefully that gives you an idea. I'm sorry, I don't have a specific site for that, but talking to agents and brokers who work in that area, also a word with caution about that as they do work off of commission. So they're likely to kind of inflate the costs most of the time, especially if you're seeing a flyer, for example, that's asking, that's not always the price, right? Let's say they're asking $4,000 a square, excuse me, $4,000 a month. Um, there's always room, in my opinion, and we can always negotiate and help you understand how to get there. But yeah, definitely invite you to reach out to our office and we can help you kind of give you that scope. And if there's more specifics, help you get there as well. One other note I do want to mention, and I always advise folks also asking when you are looking for spaces, is understanding if the utilities are separately metered or not. For example, if you are operating a laundromat, or if you're operating a retail store and there is a laundromat in the building, you want to know that your water meter is separate from that. So you're not taking in a chunk and paying for that as well. And you're only paying for what you're using.
Awesome. Thank you for that. And if folks wanted to contact your office, Iris, how would they do that?
Yes, that'd be great. SFOS SFOSB at sfgov.org. I'll put the information in the chat so y'all have it. You can email us or call us, and you can also make an appointment online to visit us and schedule a time to chat as well. And I'll put all that information in the chat.
Wonderful. Thank you so much, Iris. Yeah, this is how we really build a more empowered commercial tenant landscape, given sort of the imbalance of power between landlords and commercial landlords and commercial tenants. And so definitely stay connected, get connected, reach out for support. There's so much information and also individuals and organizations out there who want to see commercial tenants and small businesses thrive in San Francisco and beyond. And so, yeah, thank you so much. We'll keep an eye out for that information in the chat. The other thing too, before we move on here, is just in addition to asking, I think what's also been beneficial negotiating rent is also questioning. So like questioning the basis of any sort of, especially outrageous rents that might be on the table if a landlord is, somehow, being really unreasonable and just throwing numbers out there. I think what's been really advantageous in our work with commercial tenants is just asking landlords to provide the basis for why, they're proposing a specific rent if it's totally outside of, the ballpark, and then able to definitely interrogate that. And especially if there is no dollar per square foot amount being proposed. We had a client that came to us with just this outlandish rent increase from a landlord for 700 square foot. Granted, this was in San Carlo, but for $5,400, I remember when we got that ask. No, sorry, San Carlos. And we were able to interrogate the rent justifications and be able to bring that down to $3 per square foot. So ultimately, they ended up paying 2,100, and the landlord didn't really have any basis for 5,400 and was just sort of pulling numbers out of thin air. But anyways, so that's things to keep in mind for negotiating rent. Definitely reach out to Iris's team, the San Francisco Office of Small Business. All right, so next slide here.
But there is another question in the Q&A.
Oh, okay.
In see that on your end.
Got you. Okay, so this is a very specific question. I wonder if I don't know if you have any input on this question, Iris, or if it would might warrant some more conversation one-on-one. The question is, we are located on Sutter and Taylor, paying $16,000 for 3,000 square feet, not included. Triple net is not included. Is this reasonable?
Yeah, I definitely encourage you to reach out. I'm sorry, I'm not able to see the question.
Yeah, I figured. Read it
Okay.
late.
But definitely reach out and we could talk a little bit more about that. It depends. I'm sorry, I don't have the best answer for
Yeah.
you. It really depends.
Okay. Thank you. All right, so keep the questions coming. And so the last couple of things I want to keep to discuss as it relates to rent obligations is lease guarantees. And so a lease guarantee is an agreement that creates a legal obligation for another person or entity to pay rent and perform tenant obligations if the named tenant in the lease defaults and doesn't perform. The landlord can go after the guarantor that's listed in the or identified in the lease guarantee. And so the landlord may try to get a business owner or a parent company of the tenant to sign on as a guarantor of the lease if they're worried about the tenant performing their obligations, or let's say if it's a newly formed business entity, um, there can be some questions as to the assurances that the landlord is seeking, and then wanting to kind of provide more confidence of performance by having another individual obligated to sign on and back the named tenant. And so this is really important in terms of who is signing and who is entering into the lease as the tenant, because there are many times we'll have individuals who are running businesses as sole proprietors, um, or we might have a legal entity. We might have an individual who has created a legal entity for their small business, and it's very important to distinguish those two situations. If it's an unincorporated business versus an incorporated business, you really want to make sure that you're obligating the incorporated business entity as the named tenant in the lease, and then also ensuring that if it's an individual that's signing, that the individual is signing in the capacity as a legal representative or authorized signatory for the incorporated business that's named in the lease. And that is all clearly laid out in the signature blocks, because that can have some huge implications in terms of who is actually obligated to perform the financial and as well as the legal requirements under the lease. So definitely wanted to underscore that. And then if you do locate any lease guarantee, be sure to review the obligations carefully. Often there's a whole nother agreement that's attached to the lease. And sometimes it may be referenced a lot later in the lease, or maybe like a separate exhibit that's buried in the last pages of the lease. For example, in a lease that we had in the past, we've seen this often, but there might be a reference early on to a guarantor, and that the obligations of the tenant under the lease have been guaranteed by a specific individual. And so that would be the guarantor. However, the terms of the lease guarantee didn't show up until paragraph 37, which was like pages and pages into the lease, right? So just making sure that all of those subsequent agreements are reviewed in addition to the body of the commercial lease itself. All right, so then the next slide, if you do have a lease guarantee, you spot it, the best thing to do is to try to eliminate it, to advocate that it gets eliminated, that, whatever assurances or confidence that can be provided to the landlord of rent performance, that or of lease performance, that you're finding alternatives, thinking creatively about that. But if you're not able to come to a satisfactory resolution on that, and if it does stay, then at least have a limitation on the time frame. So if it's like a multi-year lease, then including a sunset clause where the obligations of the guarantor would expire, let's say after 6 months or 1 year of successful rent payments under the lease, to demonstrate that, the landlord has nothing to be worried about. So that's one way that, we've navigated negotiations around it. Um, Also ensuring that the guarantee is limited to specific scenarios and that it's capped. So the value of liability is capped to a specific figure under the lease, so that it's just not unlimited liability for any violations. So being able to limit the specific scenarios that the lease guarantee is tied to, such as just the failure to pay rent after notice and an opportunity to cure period has expired, such that one lapse in the rent payment doesn't automatically mean that the guarantor is on the hook, that there's still some sort of due process embedded in the lease so that the named commercial tenant has a chance to sort of fix the correction before, the lease guarantee being triggered. And if you can't remove the personal guarantee altogether or have it modified, definitely ensure that the guarantor is released from liability once the tenant moves out or the lease is assigned to a new tenant. And the last thing that you want is the guarantor to be responsible for a new tenant's failure to perform under the lease. So just ensuring that those things are addressed. So yeah, so with that, definitely want to pause. I don't think I see any other questions, so I'll just move us along here because I want to get into as well SB 1103 in the next few slides. So now we're going to move from the rent term, material term, to the next thing that's also really kind of high stakes is talking about repairs. So next slide. All right, so from as a small business that is looking to get into a commercial space, in addition to rent, you'll also want to be thinking about what are your build out or your repair needs for the space. So if you're a restaurant, if whatever, if you're in retail, if you're providing specific services, you want to explore the needs of running your business in the commercial space, whether you need a full build out of the kitchen or commercial kitchen, remodeling of it, bathrooms, any garage, any upgrades, right? Especially with respect to the allocation of compliance with disability access requirements, sort of depending on what the lease states in terms of responsibilities, just to ensure that all of that is handled accordingly. Are there any repair issues before the time of signing the lease that you want to ensure the landlord addresses? The best time to do that is before the lease. A lot of times, commercial landlords will include an as-is provision that states that they're not providing any representations or warranties about the condition of particular systems, whether it be electrical, plumbing, etc. So the best time really to get things in order is before signing, at least to get the landlord to state that those systems are in working order as of lease signing. And then also, again, just to emphasize the ADA accessibility considerations and costs, that all of that is sort of squared away at the beginning. If it's a multi-unit property, is the plumbing or the AC or electrical units, are they also supplying utilities to other units or services to other units, or is the source of the plumbing essentially, is it like a shared plumbing system, right? Because if there's questions about repairs, that might be the effect of, say, another tenant's mishandling or, the property itself sort of having a defect and it impacts you. Although if it impacts your leased unit, it could be that the source of that problem is outside of your leased unit, your lease premises. And so that bears on who's responsible to fix it. And so just things like that, understanding the internal, just kind of like, being able to visit the property and take a look and ask questions about sort of the systems and who all is going to be having access to it to better inform ways in which the provisions around responsibilities for repairs should be contemplated and addressed. Next slide. So here we go. Let's talk about the actual repair provisions. So you have a good sense of how the building is laid out and what you're going to need for your particular business to carry out its uses. Then now the question is, how do you allocate responsibilities to divide the responsibilities of maintaining and repairing the lease premises and the building? So typically for landlord scope of responsibilities, they fall under the structure and the foundation of the building systems, as well as the common areas. For tenants, it's usually restricted to the lease premises itself. So everything inside of the premises, including the interior, the walls, the fixtures, the lighting, the carpet. Usually those aspects are what the tenant handles and repairs and maintains. And everything outside of that, including like the roof, the foundation, sort of the inner wall bearings, the structure, that is usually within the wheelhouse of the landlord. So the building and the property versus like the actual lease premises, which is just a component of the building and the property on the property. And then the other things to think about is negotiating these specific build outs or repairs prior to lease signing. Sometimes there may be waivers in there in the lease that's sort of buried in there that waives some statutory rights that allow commercial tenants to make needed repairs on their own and then to deduct that from rent if the landlord fails to respond to sort of their scope of responsibility. So we want to make sure that that is not waived so that you have an opportunity to avail yourself of that. That remedy, if the landlord's not doing what they need to be doing. And then as well, there's usually a right of entry in the lease that provides the landlord with reasonable access to the tenant's space to make necessary repairs, so long as they're giving the tenant prior written notice before entering, unless it's an apparent emergency, and also so long as the landlord's not interfering with the tenant's business when making repairs. Next slide talks about an example of ways in which the repair provisions might come up. Usually it's like, check here if the landlord's responsible. If it's not checked, then the tenant's responsible and sort of kind of lays out the full scope. So definitely review how it's laid out in any leases that might be presented to you. Next slide. Thank you. And then here we have a presentation on how to enforce repair provisions. So let's say the lease is really clear about who's responsible to make a specific repair, but the landlord's refusing to do it or ignoring the tenant's request for that repair to be done. Now you're in the realm of enforcing the actual lease, the lease language as to, what the landlord needs to do. And so first step is to send the landlord a written notice to cure the lease violation. Usually landlords have 30 days to cure the lease violations before you can take legal action. And so if that fails, then this is something that we do often, which is to draft a demand letter. So get an attorney to draft a demand letter citing to the lease and other relevant authorities, essentially telling the landlord to perform their lease obligations, otherwise they'll be in breach of contract. And then if the landlord continues to refuse to comply, then you have the option of filing a legal claim against the landlord if your lease allows you to do the repair and to deduct the rent, you can do that. Or if you seek to have to be compensated for any repairs that you have done that were within the landlord's obligations, that's also something that you can sue the landlord for. All right, so next slide here, it looks like we have a question in the chat about whether the renewal option makes the lease a secured obligation. So, curious to unpack that a little bit more. I'm assuming you're talking about um, from a financial standpoint, if that's a secure transaction. I'm not sure. Maybe we can get a little bit more clarity or um, maybe have some time to chat more about that. All right, so I'm just going to move along here to the next subject, which is duration. And so with duration, we will be talking about the needs that you may have for the different types of tenancies. And so typically there's like a range of different terms that you can might be in or might be evaluating. So the periodic tenancy is like the weekly and the monthly sort of tenancy where you have the advantage of not being locked in for a long time, but then you don't have the security of being in one place for an extended period where either you or the landlord can terminate with short notice. And that's juxtaposed by the fixed term or the fixed long term, where you may be locked in for a longer term, then you can have all the benefits as well as responsibilities of being in sort of an extended obligatory period. The next slide talks about ways in which you can negotiate. Um, Thank you. The ways in which you can negotiate converting your month-to-month to a fixed term lease. So, before SB 1103, there was a lot of, and there still is some insecurity with having a month-to-month tenancy, but really that insecurity all depends on what you want as a commercial tenant. It could very well be that a month-to-month tenancy is serving your needs, but the only disadvantage is that prior to SB 1103, if you had occupied the space for more than a year, then the landlord could terminate the tenancy with just 30 days notice. Fortunately, now that's increased to 60 days notice. And so that's definitely, a consideration that can, maybe make it more attractive to stay on a month-to-month lease, but you still don't have the protections of a fixed term lease that offers you, more stability. So if you do want to extend it and make it into a fixed term lease, some things to keep in mind when negotiating that is just the value of being a reliable tenant and having made reliable rent payments. So, why should the landlord look for a new tenant when they already have one right here? That's been, pretty consistent. And then if you're willing to lease for longer, it means that your business is successful, which is better than leasing to a known tenant. Also, the disadvantage of the space becoming vacant, and sort of that's the solution that you're providing to the tenant or to the landlord. And then for you to have a lease that's not just sort of a month-to-month tenancy that has unknown terms, offers you just greater clarity and avoids sort of the continued ambiguity of being in sort of this more unstable sort of leasing arrangement. Next slide. And then the same thing, if you decide you want to go the other way and you want to reduce your term, ways in which to explore that could be to request a mutual early termination clause to be included in the lease, or you can offer instead maybe a shorter initial term and then add on shorter options to extend to equal maybe the total amount of time that the landlord is seeking to have you at the unit. If the landlord won't budge on lease duration, just make sure you have a flexible sublease and assignment clause in your lease such that if you do need to leave sooner than later, you're able to do that within the provisions of the lease. All right, so let's talk about options to renew. So options to renew are really valuable entitlements in the lease that effectively give you the right to extend your lease. It's not, it's not a voluntary benefit that the landlord gives you. Instead, you're the one who is in the driver's seat at the end of when the initial lease term expires to decide if you want to stay longer. And so this is the option to extend is usually it's always for a specific term and at a specific rent. That's all negotiated in advance. And so one method of securing is one method of securing the possibility of renting the premises for a very long term. But something that you'll really want to keep in mind is that in order to exercise your options to renew, there are a lot of technicalities. So there are certain actions that you have to take in order to express your interest to exercise the option well before, often it's like 3 to 6 months before the expiration of the initial term, you have to provide a notice to the landlord of your desire to extend, as well as you cannot be in default in order to be eligible for this right. And the question is, I see in the chat, if we use the renewal option, are we legally committed to a new lease term? So new lease term, I'm interpreting as an extended period of time under the lease that is part of the renewal option. So if you do use it, so if you exercise the renewal option, you send the notice to the landlord that you want to extend, then you would be committed to the lease terms that were included under the renewal option. So usually the renewal option is always tied to the either the existing lease or terms that were negotiated in advance. So it all depends. Um, all right, so real quickly, termination. So this is really important. I just kind of put the banner of like exit. So if you need to exit the lease, or if you were being, challenged to exit the lease because of, certain events. So first is in the event of a trigger of a default. So if there's been a lease violation or an allegation of a lease violation, then the landlord could terminate the lease. Some examples are failures to pay rent. Again, we talked about earlier, base rent sort of being that foundational, basis of your legal right to occupy the space. Uh, if another event of cancellation could be an assignment or subleasing without obtaining the required written consent, or vacating or abandoning the space, or any other provision that might be laid out in the lease around the events of default. And so you have an opportunity to cure the default. So you can fix the problem. Usually in the lease, there's an opportunity to fix the problem. And so sometimes this is where there will be a notice. You'll be given a notice of a violation. And so that gives you time usually to fix the problem. And in the lease, it's under the section cures. So usually it's curing the default. Eventually that gives you a chance to kind of come back into compliance. Another thing to consider from the standpoint of more positive exit is the right to assign or sublease. And so again, this is a way in which you can be more in the driver's seat to exit the lease by finding a replacement tenant to take over. And the right to cancel the lease is usually non-existent in leases, but definitely something worth exploring is having an early lease cancellation fee. Maybe you forfeit your security deposit, or you have some other arrangement to facilitate a mutual termination in order to cancel a lease. So definitely all things to keep in mind when thinking about exit strategies. All right, so just some final considerations when negotiating. Imagine the worst case scenarios before signing, sort of thinking about, attorney fees, if there are fees for the prevailing party in a lawsuit, if there were to be a legal dispute for the lease, just to consider, or if for the landlord in any circumstances where they can hire an attorney, if there are any fees that would be shifted over to you, just to have that addressed. Again, waiver of rights, especially jury trial waivers, we're against that, making sure that you're not waiving your codified rights in the lease inadvertently. And then also thinking about property taxes and ways in which reassessments could negatively affect you as a commercial tenant, and having that limited. Thinking about, the economy and impacts of the economy, such volatility and instability, the current social, economic, and political climate right now. So early termination clauses, sublease, and assignment clauses are all more important now than ever. Okay, so next slide. Want to talk about commercial tenant protections. Okay, so here we go. Now we are moving into a new era, at least. In some ways, we have more protections that didn't exist for commercial tenants. And so the Commercial Tenant Protections Act under SB 1103. I know earlier there was a question about if the new protections in SB 1103, if it does apply to a commercial lease that's already been agreed to. And so we'll be answering that as we discuss eligibility for SB 1103 right now. So who is protected under SB 1103? So qualified commercial tenants are protected. So what is a qualified commercial tenant? A qualified commercial tenant includes those leases that were executed or tenancies that were commenced or renewed on or after January 1st, 2025, or before January 1st, 2025, if the lease does not contain a provision about building operating costs. So this was the CAM, the lease that was executed before January 1, 2025. If it did not contain discussions or provisions around building operating costs, then it will be covered under SB 1103. What else is also covered are month-to-month tenancies. So regardless of them being entered into on or after January 1, month-to-month tenancies do come under the protection of SB 1103. And so that's a really big one because so many times month-to-month tenancies are neglected under the law. And so this is one area of protection that month-to-month tenancies are covered under. So who are qualified commercial tenants? Micro businesses with 5 or fewer employees, restaurants with 10 or fewer employees, or nonprofits with 20 or fewer employees. So these are the types of commercial tenants, smaller commercial tenants. This law was intended to protect the most vulnerable and most at risk of displacement commercial tenants. So these are the types of businesses that are protected. In addition, uh, the next slide talks about the next requirement in terms of getting protections under SB 1103. So a qualified commercial tenant must provide the landlord notice and self-attestation. So there is this requirement that must be submitted within the previous 12 months that includes a written notice from the landlord or from the tenant to the landlord stating that the tenant is a qualified commercial tenant and providing a self-attestation regarding the number of employees. So this is a requirement unless the tenancy is from week to week, month to month, or other period less than 1 month. The tenant must provide the notice and the self-attestation before or upon lease execution. And then you got to do that annually. And so it's at that time that the protections would come into place. Next slide. And so an example of that self-attestation is on the slide here. So this is one way in which to meet that requirement. This letter notifies the landlord of the premises located at 123 Main Street, San Francisco, that ABC Worker Cooperative is deemed a qualified commercial tenant as defined in California SB 1103, as it is a micro enterprise with 5 or fewer employees. So this is an example of how a qualified commercial tenant can avail themselves of the SB 1103 protections. Next slide. Now, some of the protections, let's assume you are a qualified commercial tenant. What protections do you have? So there are 3 categories of protections. One is language access, where landlords are required to translate commercial leases to tenants if the lease was negotiated in different languages, including Spanish, Chinese, Tagalog, Vietnamese, and Korean. So if the lease was negotiated in those languages, the landlord must provide the tenant a translated version of the commercial lease. The next protection is extended notice periods. We talked a little bit about this during the month-to-month tenancy discussions about terminating month-to-month tenancies and what notice periods are required. And so we'll discuss that a little bit more. But there are extended notice periods for rent increases as well as lease terminations that didn't exist before. And lastly, we have lease transparency, where now there is a requirement that the landlord pretty much show their homework when it comes to building operating costs and how that's allocated and charged to tenants. Next slide. So again, to reiterate, the language access piece, it amends California Civil Code Section 1632 to require written translations of commercial leases negotiated in these languages. And it doesn't matter if the tenant negotiates the lease through their own interpreter, the landlord must provide a translated version. Next slide. The extended notice has to do with amending the laws in order to provide the requirement that if the rent increase is greater than 10%, then the landlord must give the qualified commercial tenant at least 90 days notice before the rent increase can go into effect. If the rent increase is 10% or less, then the landlord has to give the qualified commercial tenant at least 30 days notice before the rent increase goes into effect. And with respect to lease terminations, the landlord must give 60 days notice prior to the proposed date of termination. And if the qualified commercial tenant occupied the property for less than 1 year, the landlord must give 30 days notice prior to the proposed date of termination. Next slide. Here's an example of ways in which we have already been advocating and asserting commercial tenant rights under SB 1103. So on January 10th, 2025, a commercial landlord says to a commercial tenant whose fixed multi-term lease had expired, here's an actual message: "Dear commercial tenant, moving forward, please note that a month-to-month implies that you as the tenant are not bound by a lease and neither is the landlord. A month-to-month rental agreement means that as the tenant, you will be able to give the landlord a 30-day notice and you will be free to vacate the space and be released from the rental agreement. Likewise, the landlord can give you as a tenant 30 days notice to vacate the space. Additionally, landlord will need to be given access to show the space to other prospective tenants when the need arises." And so the landlord has made many false statements here now that SB 1103 is in effect. And so we were able to assert that landlord needs to be informed that they are obligated to give the tenant 60 days notice before vacating the space. And that in fact, the tenant is protected by the law. And that just because it's a month-to-month tenancy doesn't mean that the tenant has no protections. Next slide. Lease transparency. And so this is a really important one for those listening in who have triple net leases or are obligated to pay CAM fees. So now, because of this law, the landlord cannot charge a fee to recover building operating costs unless the costs have been allocated proportionately per tenant by square footage or another method substantiated through supporting documentation. So there can't just be a flat fee. There can't just be a mention the triple net costs that will be calculated later. There has to be the actual method for determining that charge spelled out in the lease through a proportionality sort of calculation. And those costs have to have been incurred within the previous 18 months or are reasonably expected to be incurred within the next 12 months based on reasonable estimates. And then also there's got to be 30 days of support. So there's also an inspection requirement around the supporting documentation. And also the landlord has to provide that information within 30 days. Next slide. All right, and so here's another reiteration of the building operating cost requirement as well as supporting documentation. One thing I want to note is that if the landlord fails to comply, it may be used as an affirmative defense by a tenant in an unlawful detainer action. And so that's another important remedy that SB 1103 provides. Next slide. Okay, so I know I sped through some of the last slides, but I definitely want to lift up our commercial lease clinic that will be coming up on June 26th. It'll be from 4 to 6. We invite you to register to come in if you have additional questions. You can also email us at lsc@lccrsf.org. And I do see one question in the chat. Are tenants protected under SB 1103 in month-to-month leases after the end of lease entered into before January 2025? So if you are on a month-to-month tenancy and you have been renting for over a year and you started renting before January 2025, then SB 1103 does apply to you. All right, so I think we're at time now. If there are any other questions, I definitely invite you to follow up with us. We want to be a resource to you here at the Lawyers Committee for Civil Rights. And so with that, thank you so much for attending, and we hope that this has been helpful to you.
Thank you, Hewitt.